The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Good afternoon. Please be seated. This afternoon we have 3 cases that are being submitted. The first case is being submitted without oral argument, State of Iowa versus Edna Jean Wilson. The first case that is set for oral argument is State of Iowa versus Kenneth Lilly. And it's my understanding Ms. Knipfer will go first. And then is it Mr. Lovell who will be arguing this case? Yes. Thank you. And then we've got Mr. Sloven for the state. Okay, so Ms. Knipfer, you may begin.
May it please the court, counsel. The failure of courts to mitigate the underrepresentation through effective jury system practices is itself a form of systematic exclusion. If such practices can be identified and corrected, there is no reason to shield that practice from scrutiny just because it's relatively commonplace. That's what Lilly has told us. For a quick overview, Duren versus Missouri set forth a 3-part test for determining fair and reasonable representation, which was adopted in Plain and again in Lilly. And that test is that first, to show a prima facie case of fair cross-section representation, you have to, the group that's alleged to be excluded has to be distinctive group.
Questions of you? How many people were in Mr. Lilly's jury pool?
You mean, like how many people did they call? They don't tell us that. I mean, we just had the clerk's reports, and then those numbers are discussed in the brief. It was like, anyway.
No?
Not off the top of my head for each distinct pool.
How many didn't identify their race?
They don't tell us. Wait. I'd have to look at the charts.
Here's my question for you. If it's the defendant's burden to prove the pool was underrepresented, do you agree with that?
Yes.
If there's a substantial portion of the pool where the race is unknown, doesn't that mean the defendant loses as a matter of law because the defendant can't establish underrepresentation?
Well, I think you can't include the unknown races either way. I mean, you're working with the numbers that you have, and those numbers, so we know there are X number of African Americans, X number of whites. That's what we work with. The unknown is unknown. You can't assume that they're...
So if the defendant has to prove this pool is underrepresentative and 20% of the pool is of unknown race, how can we say as a fact finding that the pool is underrepresentative?
Then what happens is the tools that we have to measure underrepresentation are flawed in and of itself. So essentially the court has given us a flawed tool, and then we're totally hamstrung. We have to be able to, well,
should we assume that the missing data set, all of those people are not minorities? Or does the defendant actually have to prove that it's underrepresented?
I think you have to assume that they're not minorities, particularly when you're in Iowa. So, you know.
Well, without necessarily, sort of a related but different area, without necessarily agreeing or disagreeing with Justice McDonald's kind of line where he's driving at, I just want to establish the facts. As my understanding is, there was a group of something like 75 people that returned the questionnaires. Is that right? And And there were 50 or so that actually showed up at the courthouse. And they were in the questionnaire, people that have returned questionnaires. One person self-identified under race as other, and one person self-identified as black-white. And my understanding is neither one of them was in the 50 that showed up. Is that your understanding? So among the people that showed up and where we know what their race is, there were no African-American jurors.
Now I forgot where I was. Okay, so the second prong is that representation of this group in the veneers from which the juries are selected is not fair and reasonable in relation to the number of such persons in the community. And community is defined as eligible jurors. So it's not the community as a whole, it's just eligible jurors. And the third prong is that the underrepresentation is due to systematic exclusion of the group in the jury selection process. Plain allowed that you could use 3 different measurements, absolute disparity, comparative disparity, and standard deviation. You could use one or a group of them, or to try to evaluate. But Lilly held that you could only that show the whether or not it was fair representation by whether it was within one standard deviation to the negative. Also held, and that's under the Iowa Constitution. You had to use the most current statistics, and you had to deduct the non-eligible population, such as inmates and persons under 18. And then we also deducted in our calculations foreigners or people who are not citizens, 18 and older.
Kata implications for these jury pool challenges. So imagine in this case, if you have a finding by a district court that there's no systematic exclusion, is that something that the district court or something that the parties have to keep relitigating every time there's a trial?
An interesting question. I know that I've seen in other cases that I've worked on where if like in a particular case, a court found that there was underrepresentation, and so a person said in another courtroom said, Judge such and such found there was underrepresentation, and the court accepted that. But I think everybody has their own argument, and
That might be true with respect to the second part of the analysis, but on the third, unless it's a different kind of challenge, if there's already a determination that there's not systematic exclusion because of the voter lists or the motor license list, or the failure to not hold people in contempt for not responding to jury summons, isn't that dispositive on all practices going forward?
I don't think so, because it's a different case. I mean, if it was that case and it was, appealed and sent back for some other reason, that would still be holding true. But if it's a different case, I don't think it's barred.
Many courts have held that use of driver's license, state IDs, and voter registration lists constitutes systemic exclusion.
I tell you off the top of my head, and I just don't know. But I know that it has been criticized, and that a number of jurisdictions like New York and DC and Connecticut popped to mind. I think in Hannah Ford Agor's, one of her footnotes discusses, I believe it was her article, the Drake article, discusses what different states have done. And I know so New York, Connecticut, and DC, they've adopted a lot of different, they've do the tax returns, and it's in my notes.
The tax returns, but the Department of Revenue won't give us that list. So where does that leave us?
Well, the statute says that, well, federally, I mean, you can't make them comply, but the statute makes a statement about that the agencies have to hand the information over. So let's see, which, so, I mean, state agencies, I think you have more power to get the information. The Department of Human Services for child support or utility list, those have all been mentioned.
Counsel, if I might turn you to prong 3. I believe in Lilly, we said that you needed to have an expert that would testify as to the cause of the defect in the state system. What expert testimony do you point to in this case that showed that?
Counsel, I guess, considered himself, you know, he did all the calculations and drew the conclusions. And what this case says actually is that in most cases, you should have an expert. So it doesn't require that in all cases.
I think counsel's testimony would go, or not testimony, but his numbers would go to the second prong. But what goes to the third prong?
Is all the evidence he put on about the correlations between the disparity in the jury pools, and also how it ties to economics, housing, and things like that. And then from those things, we can draw so a number of those are people of low economic means tend to not buy houses. They don't have the financial means to do it. So they rent apartments instead. Those people tend to move around a lot more because they don't have that anchor of owning a home. Also, younger people tend to have less income and move around more. But
You said correlation, but that's not causation. What evidence do you have of causation here?
in the fact that we know that using these lists, the voter registration and the DOT list, we're not getting the numbers that we need. And that if we want to get those numbers,
We have a companion case pending where we have an expert who testifies that that's not true, and that the list actually does result in proportionate number of people being summoned for jury duty, and that the failure comes later on in the process. So how do we know in this case the lists are bad?
numbers that was presented in the brief, that we're not getting the expected value of people showing up. Or
To me, Ms. Knipfer, you're kind of conflating prong 2 with prong 3. When I wrote Lilly, I think what I was intending to say, and I think what the court was intending to say, was that you still have to prove more than substantial underrepresentation. You also have to prove that there was systemic exclusion. And I think we said that you have to identify a practice. It can be an everyday run-of-the-mill jury practice that ought to be changed, but you still have to show that if you did change it, things would get better or get different. And I'm struggling to see the evidence of that in this record. That's where I'm at.
is the use of the voter registration in a DOT list. And what defendant is asserting is that because it's our assertion that those are coming out with inadequate numbers. And I mean, I think the court feels that way in some ways.
I gather, and from, and the suggestion was, well, yeah, we think maybe there is some socioeconomic problem here, and we at DOT have taken certain steps and so forth. But it was generality this high. I mean, there wasn't analysis of any jury pool data, and well, if we would have used this group, we would have achieved X or Y or Z. There was none of that. I mean, there was just kind of a general notion that maybe seems kind of right, but is that sufficient to meet your burden?
I think that, yeah, when you should, by showing those correlations between economics and the actual, the lists that we're using and how we're getting lesser numbers, and then the economics showing that this group of people, are falling also in those ranges. I see my time is up.
Another question?
If you would, could you respond to, I believe it's the state's position that this jury pool was not underrepresented because there were a sufficient number of African Americans to meet the threshold. And under Lilly, we said if that's true, the defendant suffered no constitutional injury at all.
Well, the state used, for one, the person that declared herself black-white, so they added that into the numbers. And, our calculations are different.
Mr. Lovell?
May it please the court. Perhaps I can respond to a couple of the questions. Justice McDonald, you asked about the unknowns and how they're ordinarily, I think all the precedent that I've seen, if it's unknown or it's just, they're excluded totally from any calculation. I think there's a Ninth Circuit en banc decision on that a few years ago. With regard to the Department of Revenue, Justice Waterman, yeah, I know that the judicial branch has been trying to get the names. I know that we had almost universal support for getting that. I mean, it seems to me that if that's all it's holding us back, that we need here is that, decision that we need to have that and make accessible, that would take care of that issue. With regard to the, one other comment on the, the observation, or on the, if we don't know the race, in most other areas of civil rights law, for example, equal employment, or in the areas of housing discrimination, people are trained to make observations as to race and gender and so forth for EEOC and other types of reporting. And certainly that's something that, it's not rocket science to do that. So that would be a responsibility that I think legitimately the state court system could take on. And so I think that I don't think that's appropriately the part of the defense.
Could you explain that?
Manager, could make an observation when somebody shows up on Monday morning and 5 people haven't declared their race, to make a judgment call with a little training. That's done by housing people that's been going on for 50 years in the area of housing, and EEOC has done the same, and employers are expected to do that as well. So that could be handled in that fashion. With regard to the expert testimony, again, Justice Mansfield, I remember we consider it dictum from the Lilly case with regard to an expert, and that seems to be common in a number of instances. But I went back and looked at the seminal case, the Duren case from the U.S. Supreme Court. There's no expert in that case. They looked to just the jury data and the
situation where the practice was discriminatory on its face. It wasn't a discriminatory impact type case like what we have here, right? That was something where women were given a different treatment from men by the jury manager, and that, so it was discriminatory on its face, right?
True, but they still had identify where it was taking place or as best they could, in the system, and so I think.
Here, I can guarantee this court would not require an expert.
Let's see here.
On that just a little further, and let me be direct. I mean, I read the DOT's submission. I'm aware of what one might call the theory being, African Americans are underrepresented in driver's license and voting registration because of socioeconomic status, et cetera, and maybe if we included utility bills, SNAP documents, whatever. I mean, I understand all the framework, but what I'm not sure I understand is how we get to the point that if indeed we had these extra lists, the problem would be ameliorated. I mean, I understand the theory, but I don't know if I understand the fact. Help me out.
Well, I don't know that there's a silver bullet for all of these issues in the racial justice area and the jury process, but certainly, I remember from the Paula Hannaford Drake article that Justice Mansfield relied upon. I mean, she talked about the court system, has no responsibility as to whether people register to vote, or whether they obtain driver's licenses or can even afford, to have a car to make that make sense. But they do have the power, to utilize additional source lists, and they're one of the best ones would be the names from the state income tax rolls, because it's a broad cross-section now that really does file, particularly now with earned income credits and so on. So that would be, I think that'd be the number one list, and it seems to me that, that.
So I understand the theory behind this, but since you're here as amicus, I will ask you, isn't it correct that in the companion case, the expert who we relied on indicated that the summons that went out were actually proportional, and maybe they were over-representative in terms of sending out summons to minorities in the plain case. Isn't that right?
I haven't my colleague David Walker will be arguing that, but that's my recollection, yes.
I mean, we have a theory here, but we don't have evidence. And at least as these two cases are related, the evidence is actually that the list works and that there are other mechanisms that maybe aren't working as well. Is that fair?
Follow why we're convinced that the list works.
Look at the race of the people who receive summons based on the list that we're currently using.
They were doing in Black Hawk County. I don't think that would.
Not true in Lee County, other than speculation.
Well, I just think the substantial, dramatic underrepresentation of blacks at the jury pool and at the jury panel stage over a 5-year period of time, the very deep poverty of African Americans in that community. I don't have it right in front of me, but I think it just about, almost half of the black African Americans in that community are living below the poverty level. Just there's some things just, it doesn't take rocket science to draw an inference that's very likely to have a racial impact because of that poverty. It's not, the Sixth Amendment doesn't require intentional proof of discrimination. And so I think that.
Draw that line to say that it's the cause. That's sort of what I'm trying to push for here. Is it but for cause? Is it a different level of cause, a different standard?
Really got a definitive definition of that. I mean, I'm not convinced. I mean, I think it also could be just viewed circumstantial evidence. Like, for example, as I recall, Mr. Lowe's statement, why there's no race is not taken into account in any way in DOT records. So, you're not. I think the state criticized, well, you don't have a report from the DOT. Well, hey, it's impossible to get a report from the DOT. So, I mean, I think that again, you can set the evidentiary bar so high that it's almost unattainable. We also don't have a lot of these experts here in the state of Iowa to utilize as well.
Where do you think we should set that bar? If you were us, where does that causation bar get set? What evidence do we need? Because I thought in Lilly we said an expert, and it sounds like we don't have that here. I haven't seen it in this record that we have an expert sort of pinpointing this cause, at least in this case.
Evidence in this case, particularly what seemed to me to be overwhelming poverty of the African American community, and it was so deeply different from the other minority groups and from the white members of society that, I mean, I think you can draw inferences of that with also the very substantial underrepresentation at both stages, both the jury pool and the jury panel stage of the process.
I'm going to ask you to shift gears a little bit, Mr. Lovell. I have to say, I was impressed, and I think I found fairly persuasive your kind of reanalysis under prong 2 of that took into account the fact that there were multiracial people listed in some categories and not listed in others, and you need to get a like-to-like comparison in order to figure out whether there's underrepresentation or not. And it really did persuade me. The problem is it wasn't litigated below, as I understand it. And so what are we supposed to do with that? I mean, are we stuck with the arguments and the record as it was litigated below, or can we reanalyze the data as you want us to do?
It was clear from the Lilly case that it's if the state, and I think you'll see this often. I mean, the state often will be in a situation where the number of African Americans that are in the immediate pool or panel isn't as good as they'd like to have them. So then they'll really work hard to find mixed race and people of color. I mean, that was certainly true in the Veal case where it was done the first time we saw this happen. I mean, the sheriff actually was sent out to track down some of the people who didn't show up to see if we couldn't, and it did make a difference. But it seems to me, since that was directly ordered to the district court to on the remand, and that was the instruction that in this case, if the state's going to include the mixed race individual in their count, why you've got to do the same on the other side. So I mean, it seems to me like that's a clear error. And I'm sorry.
You may wrap up.
Okay. Well, if I'd had time, I would have also made a presentation that we think on the statistical side, the proof of both at the jury panel stage of this case, where he had no African Americans out of 50, that satisfies the standing requirement under Lilly. And the aggregation is not questioned in terms of that for the 5 years, everybody was included, and you had a small number of jury trials out there, so it made sense to go back a good period of time. The aggregation is beyond 2 standard deviations. We only need 1 here. The only argument that would be left would be the state's argument, this very innovative argument, I guess, in terms of the idea that you just look at the sole jury panel and then you somehow just minimally aggregate one by one, or you don't aggregate at all. We believe that that's directly contrary to all the case law. There's no precedent for doing that. It's inconsistent with the statistical convention. It opens you up to manipulation and so forth. So we would certainly ask you not to take that step. Thank you, Your Honor.
Thank you, Madam Chief Justice, and may it please the court, counsel. Good afternoon. Louis Sloven on behalf of the state. It's a privilege to be here with all of you. This case is easy to resolve on prong 3. This court needs to provide guidance on prong 2. On prong 3, Justice Appel, I hear what you're saying about the theory, and as I understand it, the theory is that people who are lower income are disproportionately less likely to get driver's licenses or non-driving IDs, or to register to vote, African Americans are disproportionately likely to be low income, and therefore they're disproportionately likely to be excluded from source lists. Now, the first problem, as has been articulated, is there's no proof in this record that that's what's happening. There's just an attempt to draw an inference from a correlation, and I don't want to be glib, but it sounds like Mad Libs, that it's just, here's a fact, that they have a pattern of underrepresentation for which there could be multiple explanations, one of which is choices made by individual people in their individual lives in how to respond to a summons. And then identifying a stat about the distinctive group, and then saying that proves that something about the juror selection system is causing underrepresentation. And you can fill in that blank with anything. It's not, I just don't think that there's any actual proof of causation here between the low income status and the absence from those lists, much less anything that the juror selection system is doing or not doing.
Right. You go ahead. You go ahead.
Letter is kind of interesting from Mr. Lowe. On the one hand, it's quite clear that he has no statistical study of any kind to present. On the other hand, he states that the DOT has been concerned about lack of representation coming out of driver's license lists, and he articulates the theory, and then he goes so far as to say, we've done a number of things to make it easier for people of low economic status to get driver's license and identification. So here we have a top-level officer of a major department saying, well, we recognize the problem, and we've taken steps to try and achieve it. That's not no evidence. It's not a statistical study, but haven't the plaintiffs at least shown that there is significant concern by a major government actor on underrepresentation in driver's license lists due to socioeconomic status? And they've also shown that in Lee County, African Americans are way disproportionately represented in persons of low income means. So have they done enough inferences to drive the case home, is what I'm saying?
Basically, I have three responses to that. The first is that this letter, so beyond being based on anecdotal common experience, not actual data, but this letter then says, it identifies that the state is trying to take, or DOT is trying to take measures to alleviate the disparity that it believes exists. So I think that right away you're on a level of, well, what could be done that isn't being done, right? Which is what you would need even for systematic negligence. Some reasonable care could have been taken and wasn't. Now, and to wrap up this first response about the letter, I'd compare that to the proof in Burgui v. Smith, where the court said that it was insufficient evidence of systematic exclusion because it was just the testimony of a jury official who believed that the siphoning was causing underrepresentation in that stage, and without any data to show that it was happening. So that's one. Number two is, we actually know, as long as we're going outside the record for facts, we actually know from the companion cases, as was pointed out, we have Appendix B from the filings in Plain that details 2019 data from Black Hawk County. Now, this is the same source lists, but using the postcard and the online questionnaire that requires an answer on race. Now, this is different from what we had for Mr. Lilly's trial. Not only was race optional, leading to about 30 to 40% non-responses every time. I think it was 38 non-responses for this particular pool. Now, and in this Black Hawk 2019 data, it's required. And what this is showing for the same source lists, that 10.85% of the jury pool is identifying as African American, exceeding the 7.6% population parameter. So if we're gonna look outside the record for facts about these source lists, the first thing you run into is evidence that they are functioning as, they're not causing underrepresentation in other counties where they're being used. Now, we don't have that data in the record for Lee County for Lilly, and you would run into the same problem about Northley versus Southley, which is generating a lot of confusion here. I also, Justice McDonald, you pointed out that there's an expert report in Plain that does geocoding analysis and reaches much the same conclusion that at the stage where questionnaires are being sent out, there is not underrepresentation that you would expect to see if the source lists themselves were causing underrepresentation. Now, Justice Mansfield, you asked about, I'm sorry, I had a third response to your theory, Justice Apple, and that is that even if this were the case, that people of lower income are not getting driver's licenses and non-driving IDs and not registering to vote, it is hard for me to see how that is attributable to the system for selecting jurors, for drawing juror names. I did not find a court that found that. There was one exception. It was the district court in Green, but that was reversed on appeal. And I think that was the same claim that was being raised, but reversed on appeal. So I don't think that that's something that you can attribute to the system as systematic exclusion.
Doesn't that prove the case? I mean, if time in and time again, the system keeps on coming up with disproportionate numbers, isn't there a point at which that's adequate proof?
No, I would disagree with that. And the reason is, as Justice Mansfield pointed out, that collapses prong 2 into prong 3. That says, well, I think prong 2 is a particularized inquiry to the level, the fairness and reasonableness of the representation in the group from which the defendant's pool or panel or jury is drawn. But Lilly was very clear, Lilly 1, was clear that numbers alone don't suffice. You need to prove causation, prove the feature, the practice of the juror selection system that has caused underrepresentation. I like to go back to Duren for this on page 366. When they make the transition from from prong 2 into prong 3, they say that the defendant must show that underrepresentation, quote, generally and on his veneer is due to systematic exclusion. So I think that both incorporates a requirement of underrepresentation on his veneer and also a causation requirement that I think Lilly accurately incorporated.
Turn to prong 2 now, where you said the state can win on prong 3 and everyone needs guidance on prong 2. What is your criticism of it, your solution, and I want to posit this to you. My understanding of the statistical deviation, standard deviation analysis is that it's supposed to measure the representation on this particular pool and not the 5 years previous pools. Is that your understanding or am I missing it?
Yeah, I think that's what I'm here to say, Your Honor, is that the reason that that standard deviation is a good test to use is because what we're measuring on prong 2 is was the defendant's pool or panel fair and reasonable in relation to the prevalence of the group in the overall jury-eligible population. And we've decided that fair and reasonable means this is a pool or panel that you would expect to draw randomly in a perfect world. That it's when you flip a coin 100 times, you're not going to get 50 heads, 50 tails every time. You're going to get results that cluster around there. And those results that cluster around there, they're not perfect. There's going to be some under, some over-representative. But those are fair and reasonable results of random selection.
That, it has to be, you have to attain statistical significance. I mean, otherwise the statistics are worthless. So with 50 people, you're not going to get statistical significance, right?
You could, depending on the size of the group in the community. And that's why it's going to be a little bit fact-dependent and case-dependent, the minimum size of the pool or panel that you need. There's an equation for it. But in practice, what's going to be easier is to do guess and check. And here's the rule of thumb. I think that in order to vindicate the promise of Plain and Lilly, that no matter how small your group is, if there's total exclusion as a result of systematic exclusion, you should be able to raise this claim. I think that that's fair, and that's what this court intended to do.
We said in this same case 2 years ago, right? I mean, I guess we do that, but it is changing it, isn't it?
So I think that it's fleshing it out. Now, what I understand from the response to the petitions for rehearing from the footnote is this court said it was leaving open the question of when there is a sample that is large enough that there should be no more aggregation. And what I'm saying is that in many cases, you're already there with the actual jury pool and panel. And the reason is because there is a level, total absence or something close, where there would be statistically significant underrepresentation. That as this one standard deviation test, which is more permissive than the state proposed, which is part of why it works at lower sample sizes.
In communities where there are, as a percentage, a smaller number of minorities, and within the standard deviation analysis, your expected outcome would be 0 minorities in a pool. What are we supposed to do then? Because that comports with what we think should happen statistically. So do we have to run this analysis every time that occurs?
Right, and I agree, that's the situation where you do need to aggregate some data, because 0 is a response that's that's close enough to the average that it's within the bounds of what we would call fair and reasonable. The problem is it's 0, and we won't tolerate a situation where there's no claim to be brought from total continuing exclusion of a group by attributable to systematic exclusion. So what you do in that situation is you go back, you aggregate prior jury pools one by one until an expectation of non-zero representation emerges. And there's an equation for it. It's in the briefing. It's a remand exhibit, but it's easier to do guess and check. And the way you guess and check is add in the prior pool or panel, and then see is standard deviation greater or less than the expected value, the average people we would expect from the group to be in a group of this size. If standard deviation is bigger, then when you have no people from that group, you get a z-score it's better than -1. It's between -1 and 0. So you can't satisfy Lilly. And that means, well, so if the group is absent, I need to aggregate another pool. Now, there's been some criticism that this is the state's way of manipulating data. And nothing could be further from the truth. The advantage of this is that it sets a clear guideline for what data set to use. That you can review and you can say, this is the right data set to use. I know that because the expected value, population parameter times size of the group, the amount of people from the group we'd expect to appear, is greater than standard deviation. If you take that number minus standard deviation, it's above 0. If there's no people, you've got a z-score that's below -1 and you've carried your burden of proof on prong 2, right? We know that, and then you stop. You don't look at the next jury pool and say, well, there's 2 African Americans on it, it's good for my case.
Earlier question I asked. So when you have a jury pool with the expected expectation of 0, and then a district court aggregates enough data to make a finding, et cetera, what are the res judicata implications of this type of litigation? I mean, it's clearly, maybe it's offensive collateral estoppel, maybe it's something, but if you have one district court judge 1 week in a county who does all the analysis and reaches a certain finding, does that judge have to keep doing that every single week? How do we deal with this as a practical matter?
2, when you analyze the same numbers, you should get the same result. So it should be, now next week, or next month, I guess, when you have a new jury pool or jury panel, you're gonna have new numbers to analyze. You're gonna have a new level of actual representation as well that may meet or not meet expectations. For prong 3, I tend to agree with you that in May, you get a claim that the source lists are underrepresentative. You fully do the analysis, and then you find that they're not causing underrepresentation or exclusion. In June, the same claim is made, and I mean, the law should apply to the same facts or similar facts in a way that reaches the same result. And I don't know that I would say that a defendant shouldn't be permitted to put on proof if they think they have additional proof. I mean, what we're dealing with here is a pretty clear gap in the necessary proof that would be needed to prove this claim. And so if somebody thinks they have it, I want to hear it. So I would have questions about, I think it would have to vary case by case in light of the kinds of theories that are being alleged and the kinds of facts that are being presented. But I think that when this court or an appellate court makes a decision on a developed factual record and says, we've thought about it in this kind of jury practice can't be systematic exclusion. That should be preclusive. I want to emphasize that.
Thank you to prong two. As I understand it here, the way that the numbers were put in place was you took the population of Lee County in total, you cut out Keokuk, and then doubled the expected population of blacks in the rest of the county. Is that right?
Whatever was left, Fort Madison was more than half of whatever was left. So we're saying when you take out rural South Lee County, we don't know exactly what effect that has. There's no possible way it doubles.
But how do we know that?
There were about 17,000 people left in all of Lee County minus Keokuk, about 10,000 in Fort Madison. So about 7,000 in all of the rural areas between North and South Lee. Even if all of them were in South Lee, or if mathematically there's no possible way for removing the remaining part of, right? So assume that all 7,000 remaining people are rural residents of South Lee County and that they're all white, okay? Doubling the parameter would assume that there's 9,000 of them and they're all rural South Lee and they're all white. There's no possible way for the parameter. Now, I do think there's a interesting critique about the failure to include a multiracial parameter here. It really wasn't litigated below, is why we weren't able to make.
Isn't it? I mean, if there, if you treated somebody, let's, hypothetically, like President Obama as African American when he appeared for a jury pool, but then you said he's mixed race because he had a white mother, for purposes of the census of the county and the eligible jury, then that's a problem, isn't it?
Yeah, I think that you're right about that, and it's interesting because the way in which African Americans have been treated as a distinctive group is that in a lot of ways, or I think that it depends on the parameters of the challenge that are being brought. I think a lot of times we're imprecise, both litigants and courts, in identifying whether this is alleging that African Americans, single race African Americans are the distinctive group, or anyone who shares African American identity is the distinctive group. And even when we say that we're being precise, sometimes we're not as good as we could be at adjusting the parameters. Part of the problem is that accurate data for the best data we have, the state data center is a fantastic resource. It's excellent. It adjusts for, adult age and citizenship, but it uses the census data that's only African Americans alone.
The NAACP followed a reasonable approach on how to allocate the people who were mixed race to the various minority populations.
I think that, I might develop it differently on a factual record, but I think it's reasonable enough. I don't think this court needs to determine exactly what the parameter is. In our brief, we're laying it out that as long as this group is 0.941% of Lee County eligible jurors or less, then the claim fails on prong two, even if you aggregate 5 years. If it's more than 0.941% and less than 3.437%, then you have to decide if you're going to do the aggregation analysis, because then it makes a difference. Now, for the numbers, Justice Mansfield, you're right, 50 people appeared on the day of trial. We got, I think, 76 questionnaires back. One of them was someone who is not eligible at all, so 75. None of the 50 people who appeared were African American. Of the 75, there was one who wrote black, white, another who wrote mixed, but we don't have better data about that, and then one who wrote American. So what I want to focus on is the 75, because the allegation of systematic exclusion causing underrepresentation is only related to the source lists. There's nothing in this case about some function of the jury selection system is causing people who received or who were drawn and received questionnaires not to show up. I also want to point out that the jury manager testifies, Ms. Wilson testifies at page 38 and 39, that when a person marks, it used to be just a checkbox handwritten form for some parts, and then other parts would let you write something in. She testified that if they indicated membership in more than one racial group, she would usually, she didn't know exactly what she would do, but she said she would usually code them as other, which means that when you look back at the aggregated data, you're not seeing people who listed multiple racial categories and one of them is African American, if you're just looking at the category black. So again, I think that it's important to provide guidance as to what the analysis should look like. I think that there are problems with the data collection that make it harder to point to this data and say it's proof of underrepresentation, especially, Justice McDonald, you pointed out that significant percentages of non-responses over time, something 30 to 40% is what we see. And then when we have data from subsequent, after these 2018 changes, we are seeing better representation, but we haven't changed the source lists. Better representation specifically in the responses we're getting to questionnaires. We haven't changed the source lists, and we went from a paper to postcard, but
generally disproportionately do not identify race when responding to government questions. That's my understanding, which I guess it seems to me that if you're just excluding a whole bunch of data where somebody doesn't identify, you're potentially excluding a number of minority respondents.
right, and then you're looking at, you look at the aggregated data and you're saying something in this process is excluding people of minority identification, but in reality they're there, they're just not marking their race. I think it's a very slippery question to get good data on, please tell me about your race, which you are reluctant to identify. But the research that I have seen suggests that there are at least non-random patterns that correlate with race to some degree, in at least some contexts, some of which are, and we talk about this in the remand in Veal and Williams and in some of that briefing, but, and I don't think you need to find that that's.
Should that failure fall? If it's the defendant's claim and the defendant has the burden of proof and you can't draw any meaningful conclusions because of significant gaps in the data, why doesn't that resolve the claim?
I think in some ways it should resolve the claim. I think that there can be data or evidence presented that could warrant an inference to fill that gap. I haven't seen any of it in the record in this case. And I have seen, if you're going to go outside the record, as we've discussed, there's evidence that would support, or at least, counsel to use caution in trying to draw the inference that those, if your normal starting assumption would be that those non-responses are equally distributed across people of all races, that's not necessarily the case. And we've got some data from at least some contexts where the government's asking that shows the contrary. Now, I just want to return, because I think that critical thing to do is to say what the court should analyze, what district court should analyze when it comes to prong 2. We know that there are non-random patterns in human behavior, and that would include responding to jury summons, appearing for jury service. So when you aggregate the data over time and you'd get a statistical significance attached to a finding of some level of underrepresentation, I think our brief shows that it can be tiny underrepresentation over time. Once your sample gets that big, you've got pretty significant exponents attached to your statistical significance. All that means is that there's a difference between the population you expected and the population who is showing up, some non-random pattern. But human behavior is non-random, and over time, you can find statistically significant effects in any degree of non-random influence. What Lilly did, in my view, and I think that's what this court should clarify, is you put down a marker at the expected average. You say that African Americans are 7.5% of the jury-eligible population of this county. We expect, in a perfect world, there's a bell curve around that 7.5%. And if you're within for each jury pool, each panel, if you're within a certain one standard deviation range of that, can be some, sorry, I see my time's expired, if I can have a moment. Thank you. Thank you. You can have, there's going to be some overrepresentation within reasonable bounds, right? Now, the defendant can come in and say, over time, there's a pattern of underrepresentation. The real average is not really 7.5, it's more like 6%. But the critical realization is in a perfect world, it would be 7.5. If it were perfectly random, if people really were making random decisions, if we were getting a perfect randomized selection process, it would center around that 7.5. And this defendant would have no right to any better, any more representative jury panel or jury pool than was drawn. That if you solve all the problems, this jury pool is one that you'd still expect to get a pretty significant percentage of the time within that one standard deviation range. And there can be no constitutional right to a higher level of representation than falls within that range that we would say, even in a perfect world where we've solved every pattern of human behavior that makes this in any way non-random, even in that perfect world, this would occur. This would occur a lot. So there can't be a right to any better level of representation than that.
Thank you, Mr. Sloven.
In this pool, there was no people of color. And then in the reply brief, we would direct you to, we looked over 2 years, and there's still, very few people of color serving in these jury pools. Justice McDermott, you asked how we can draw the line to prove cause. In the law, we use indirect evidence all the time. And I think this is a situation where, we're using indirect evidence to prove our point, in that we can draw the inferences that these are the lists we're using, and this is the results that we're getting as for members of the African American members of the jury pool.
I don't know. I mean, that isn't what we, number one, that isn't really what we said in Lilly. And number two, even if you take on, let's say, an employment discrimination case, it's not enough to walk in and say, of this identifiable group, there's a lower percentage than you would expect that work at this company. Therefore, this company is discriminating against that group. I mean, we said in Pippin, you still have to identify a practice and put on proof. It can be inferential through statistical evidence, through experts, but you still have to put on proof that that practice is what's driving the underrepresentation, right?
So the practice of using these lists, and this is the result that we're getting. I think that is the proof. I think you're correct in that there's a problem with the multiracial and the mixed race versus black. Just even in like the prison population, they combine people who are black and mixed race. So actually, when we deducted our prison population for African Americans, that's an overestimate because it's actually African Americans and mixed race. But to do this analysis, we need to be consistent, and so I don't think we can, necessarily extrapolate without having more evidence of percentages. But I mean, that's an issue in this. And then I'm going to stop here and because to let Mr. Lovell continue. And for the reasons here and in our briefs, we respectfully request defendant's conviction be reversed.
It's on the clock.
I wouldn't call it manipulation, but it was the state that chose to focus on the jury pool with one mixed race out of 75 as opposed to 0 blacks out of 50. We wouldn't even be in this question of a multiracial in this case if it hadn't been their choice to focus there. And they shouldn't be able to dictate the focus. I mean, even throughout all of the minimalist argument that's made, none of that is dealing with the, it's the, under the Duren case and also under the other case from the Supreme Court. It's the defendant who can choose which one. And the further you go into the process, that's the more relevant it is. I mean, in other words, the panel is far more relevant to fair cross-section than the pool. The pool cases is what you've dealt with so far because we've had we're just starting from scratch with Plain, but now the cases are going to be at the pool level and maybe even at the voir dire level. And if you look at
Under prong two, how far back should we look? How far back should our data set go?
all of the case law out there says usually 6 months. You use a uniform period of time so nobody can manipulate it. Sometimes, like Paula Hannaford-Yeager likes a year. But the idea that Louis is suggesting you're just going to incrementally go back and pick up an extra panel to try to get to one standard deviation, it sounds like manipulation. Public will believe it's manipulation. It's going to be more complicated. There's no precedent for it, either in the literature or in the court system.
Argument that the defendant shouldn't expect to have a jury pool that is more representative than what we would expect at random. Meaning that if we frequently expect, just based on the population, that the number of minorities in the pool is 0, how do we determine or distinguish between when there's a constitutional violation and there's not? Because I think what he's saying is sometimes it's going to be underrepresentative, sometimes it's going to be overrepresentative. That's random, but if it's within the standard deviation, then there's just no injury at all.
Well, first of all, I want to encourage us to be thinking more about the panels, not the pools. The pools are yesterday's issue. You know, the panels are where it is now, and that's under the U.S. Supreme Court case law as well. I mean, if in fact you're in a very small, county or a very rural county with almost a meager or no minority population, the fair cross section could be exactly 0. I mean, one of the things you have, though, here's an answer for you. I mean, one of the things that's on your docket with regard to the pending amendments to the rules of criminal procedure is a change to the change of venue rule that would give district courts more latitude in some of those, if you've got an African-American defendant, to maybe have him or her to have a chance to have a jury of their peers by transferring the case from Fort Madison to Davenport, perhaps.
Resolve the tough case then, if, let's assume we do as you say and we aggregate 6 months of information. And in aggregating that, the expected value is still 0. So when a defendant arrives on the day of trial and there are 0 minorities, what is the constitutional injury if the expected outcome is 0?
I think if the aggregated data is done reliably, and you're talking about like at the panel stages as opposed to just the pool stages, I'm not sure that there is a claim. Thank you very much.
State versus Lilly is hereby submitted. We'll have a brief transition here. There's a change of some of the lawyers involved for the case of State versus Plain.